What if I told you that the money you've been paying into Social Security your entire working life, the money that was supposed to be there when you retire, could be reduced or even taken away, and there would be nothing you could do about it? No appeal, no court hearing, no recourse. That sounds impossible, right? Sounds like something that couldn't happen in America. But here's the thing: for decades, the federal government has operated under a legal framework that gave bureaucratic agencies enormous power to interpret the laws that govern your benefits. And for most of that time, courts simply went along with it. If an agency said, "This is what the law means," judges would defer to that interpretation, even if it didn't seem right, even if it hurt people, even if there was a better reading of the statute sitting right there in plain English. That was the reality for millions of Americans who depend on Social Security, but that reality just got shattered. The Supreme Court of the United States handed down a ruling that could fundamentally reshape how Social Security operates and how every federal agency in this country makes decisions that affect your life. And this wasn't a close call. This wasn't a 5-4 split where you could write it off as political. This was 9-0. Every single justice on the bench agreed that almost never happens. And when it does, you need to pay attention because it means something foundational just shifted beneath our feet. Now, to understand why this matters so much, you have to understand what was happening before this ruling came down. For years, the Social Security Administration has had enormous discretion in how it interprets the rules around benefits. When someone applied for disability benefits or retirement benefits and got denied, they could appeal. But here's where things got ugly. The agency that denied you in the first place was also the entity interpreting the rules that governed your denial. I'm Nancy, and welcome to Senior USA Hub. Think about that for a second. The same organization that said no to your claim was also the one deciding what the law actually meant. And when you took that fight to court, the court would look at the AY's interpretation and say, well, they're the experts, so we'll just go with what they decided. That doctrine had a name. It was called Chevron deference. And it was one of the most powerful and controversial legal principles in American administrative law. Under Chevron, if a statute was ambiguous, meaning it could be read in more than one way, courts were required to defer to the AY's reasonable interpretation. Not the best interpretation, not the most fair interpretation, just a reasonable one. And reasonable is a very low bar. What that meant in practice was that agencies like the Social Security Administration could adopt interpretations that favored the government, that reduced your benefits, that made it harder for you to qualify. And courts would rubber stamp those decisions as long as they fell within that wide zone of reasonableness. That's not justice. That's a system tilted against the very people it was designed to protect. And millions of Americans felt the impact of that tilt. People who worked their entire lives paying into a system that promised them security in old age only to find that when they needed it most, the rules had been interpreted in a way that left them with less than they expected or nothing at all. Seniors who were told their benefits would be calculated one way only to find out that the agency had quietly adopted a new interpretation that reduced their monthly check. Disabled Americans who were denied benefits not because they didn't qualify under the plain language of the law, but because the agency had decided the law meant something different than what it actually said. That was the world we lived in before this ruling. But now the ground has shifted, and it has shifted dramatically. The Supreme Court, in a unanimous decision, overturned Chevron deference. They said that courts can no longer simply rubber stamp agency interpretations of the law. Instead, judges must exercise their own independent judgment about what a statute means. That might sound technical, but let me tell you what it actually means for real people. It means that when the Social Security Administration tells you that you don't qualify for benefits based on their reading of the law, you now have a real shot at challenging that decision in court. It means that a judge will actually look at the statute independently and decide for themselves whether the agency got it right instead of just assuming the agency must be correct. It means the playing field just got a whole lot more level. And this doesn't just affect Social Security. This ruling touches every single federal agency that makes decisions affecting American citizens: the IRS, the EPA, the Department of Education, the Veterans Administration. Every single one of them just lost a massive legal advantage they've held for 40 years. But let's stay focused on Social Security because that's where this hits closest to home for the most people. There are currently over 67 million Americans receiving Social Security benefits. That's not a small number. That's roughly 1 in 5 people in this country. And every single one of them is affected by how the Social Security Administration interprets the laws governing their benefits. Now that Chevron is gone, every one of those interpretations is potentially open to challenge. That doesn't mean every interpretation was wrong. Many of them were perfectly reasonable and would survive independent judicial review, but some of them won't. Some of the agency's interpretations were adopted precisely because they knew courts would defer to them. They knew they could push the boundaries because the legal system had their back. That safety net is gone now, and the implications are enormous. Now, here's where a lot of people get confused about what this ruling actually does and doesn't do. Some people hear that Chevron deference has been overturned, and they think that means Social Security is being cut or that benefits are going away. That's not what this is. This ruling doesn't reduce anyone's benefits. It doesn't change the amount on your monthly check tomorrow morning. What it does is far more significant than any single policy change. It changes the rules of the game itself. Before this ruling, the government was playing with a stacked deck. They got to interpret the rules, and the courts had to go along with it. Now the deck has been reshuffled. The courts are back in the game as independent arbiters of what the law actually says, and that changes everything going forward. Think about it this way. Imagine you're playing a card game and your opponent gets to be both a player and the referee at the same time. Every time there's a dispute about the rules, your opponent gets to decide who's right. How many of those disputes do you think you're going to win? Not many. That's essentially what Chevron deference allowed federal agencies to do. They were player and referee simultaneously. And now the Supreme Court has said no more. You play the game. The courts will referee. That's how it should have been all along. But what does this actually look like in practice for someone who depends on Social Security? Let me give you a real scenario. Say you're a 63-year-old worker who has been paying into Social Security for 40 years. You apply for early retirement benefits, and the agency calculates your benefit amount based on their interpretation of how certain income should be counted. Under their interpretation, some of your earnings don't count the way you expected, and your monthly benefit is $200 less than what you calculated on your own based on reading the actual statute before this ruling. You could challenge that in court, but the judge would look at the agency's interpretation and say, well, it's reasonable, even if your reading might also be reasonable. Agency wins. You lose $200 a month for the rest of your life after this ruling. That same judge has to independently examine the statute and determine which interpretation is actually correct, not which one is merely reasonable, which one is right. That's a fundamentally different question, and it leads to fundamentally different outcomes. Now, multiply that across millions of beneficiaries, and you start to see the scale of what just happened. But I want to be honest with you about something, because I think honesty is more valuable than hype. This ruling is not a magic wand. It doesn't mean that every person who was ever denied benefits is suddenly going to get approved. It doesn't mean that every unfavorable interpretation by the Social Security Administration is going to be overturned. What it means is that you now have a fair shot. The legal playing field has been leveled in a way that it hasn't been in 4 decades. And that matters enormously, even if the results play out gradually over time rather than all at once. There's another dimension to this that most people aren't talking about, and I think it might be the most important one. This ruling doesn't just affect cases going forward, it creates a framework for reconsidering past interpretations that were only upheld because of Chevron deference. Think about all the Social Security cases over the last 40 years where someone challenged the AY's interpretation and lost not because the agency was right, but because the court was required to defer to the agency. How many of those cases would have come out differently under the new standard? We don't know the exact number, but legal scholars are already saying it could be significant. Now, that doesn't mean all those old cases are automatically reopened. The legal system doesn't work that way, but it does mean that similar challenges brought today on the same legal questions could reach different results. The precedent has changed, the framework has changed, and that opens doors that were previously locked shut. There's also a political dimension here that we need to address because some people are trying to spin this ruling as either a liberal victory or a conservative victory. But the 920 vote tells you something important. This wasn't about politics. This was about a fundamental principle of American government. Courts interpret the law, agencies enforce the law. Those are separate functions, and they need to stay separate for the system to work properly. When you collapse those functions and let agencies both enforce and interpret, you create a concentration of power that the founders of this country specifically designed the system to prevent. Whether you lean left or right, whether you vote red or blue, that principle protects you. Because the agency that has power over your benefits today might be run by people you agree with, but tomorrow it might be run by people you don't. And when that happens, you want an independent court standing between you and that agency, making sure the law is being applied correctly, not just reasonably correctly. That's what this ruling restores, and that's why it matters for every single American, regardless of where they fall on the political spectrum. So, what should you do right now if you're someone who receives Social Security benefits or expects to in the future? First, don't panic. Your benefits are not being taken away because of this ruling. If anything, your benefits are now better protected because there's a stronger check on the agency's power to interpret the rules in ways that might not favor you. Second, pay attention to how this plays out over the coming months. There are already cases working their way through the court system that will test how this new standard applies to specific Social Security questions. Those cases are going to set important precedents. And third, remember that this is your system. You paid into it, you earned it. And now, for the first time in 40 years, the courts are truly in your corner when it comes to making sure you get what the law promises you. That's not a small thing. That might be the biggest thing the Supreme Court has done for ordinary Americans in a generation.